Good afternoon, everyone, and welcome to this month's Employee Benefits Compliance webinar. As we are kicking off here, as we often do, I would like to start by asking our audience a couple of polling questions. This month's polling questions are focused on GLP-1 drugs and how your company covers them and how they, if they do cover them, what controls are in place. And if you are answering those questions, we do thank you in advance for your answers to those questions. And as you are doing so, I will cover a couple of other items. So again, welcome to today's compliance webinar. I am Jenny Bedeaux with Assurex Global. Today, we will be hearing a mid-year regulatory update from Loomlight. And we would like to extend a special thank you to your local benefits advisors and consultants who are partners of Assurex Global for making this webinar series possible. We do welcome your questions during today's presentation. Please submit those over to us using that Q&A function at the bottom of your screen. We will address as many of your questions as we can throughout our time today. And our session today is being recorded. The recording, as well as the presentation slides, will be available early next week from the benefits advisor who invited you here today. And I will also drop a link to the presentation slides into the chat area here in just a couple of minutes. And if you are just joining us, you will see a couple of polling questions up on your screen about your company's GLP-1 coverage. We have asked that first question, how does your plan currently cover GLP-1 drugs? Actually, over the last 2 years, and we are curious how those responses have changed since we last asked. And we do certainly appreciate your responses to these polls that we ask every month. Your responses help inform our monthly market check surveys and provide valuable insights into how you and your fellow employers are thinking about and approaching various employee benefits topics. So I'm going to let this poll sit up here for just another couple of moments as we get our last few responses in. Our sync preview would say the majority are covering them for diabetes only, but we do have about a third of you who are not sure how your plan is currently covering those GLP-1 drugs. And for those of you that are covering them, it looks like prior authorization is a very common thing in place, but most of you have no controls in place. But I will share these results out with you so you can get that visual of how your peers responded. So you should see that those responses up on your screen. And again, I will have two related polling questions at the end of our session here, so please do stick around for those. But for now, let's get into today's content. Joining us from the Loomlight team, we have Marissa Rufo, who is their Senior Compliance Advisor, as well as Regan Debin, Director of Compliance Consulting. So Marissa and Regan, I will turn it over to you.
Thanks, Jenny. All right. We are getting started today not with GLP-1s, although also a very hot topic. Today's webinar is going to cover a handful of regulatory updates, kind of this mid-year, summer, spring update series. The agenda today is going to be about the proposed rule for fertility benefits. We'll get into that first. Tobacco surcharge cases and kind of the uptick in a little bit of spotlight on those wellness plans. New Jersey and their Medicaid enrollees penalty or annual fee, whatever you want to call it, but also some other states might be running the same program. And then CVS winning their Arkansas ERISA preemption case and related kind of ERISA preemption updates. First to go is the proposed changes for fertility benefits, which is always a hot topic, cyclical in nature. We get a lot of questions about fertility benefits and how to offer them in the plan or not. Right now, we have a proposed rule about making fertility services and benefits accepted benefits. So categorically switching how we think about them outside of the major medical plan and allowing them to be accepted benefits. There was a comment period open until July 13th, which just happened a few days ago on the proposed rule. So they will be collecting those comments, seeing, what they glean from that before they finalize this, if they do. When would this apply if we are going into effect? That would be for January 1, 2027 plans. So you have a little bit of runtime when you're thinking about that. What does this mean in reality? If this rule is finalized, there are certain fertility services benefits that would be categorized as accepted benefits. And why would we want that for any of our plans? Well, because accepted benefits are exempt from certain compliance obligations, specifically related to the ACA and some HIPAA obligations. So you get out of a little bit of what you do with your other plans. Why is this being introduced in general? There were a handful of executive orders as well as kind of some administrative goals with expanding access to not only in vitro fertilization, but other family planning or infertility services and benefits as a broad goal of the departments. And this is just kind of the rule coming out of that administration's focus, expanding avenues to make fertility benefits, family planning benefits a little more affordable by making them accepted benefits plans. How would these benefits kind of meet the conditions of this proposed rule? Well, there's kind of four main bullet points of how you could meet the new kind of structure to make those fertility benefits fit this criteria. You're going to have scope of what kind of benefits they are, a maximum lifetime dollar limit associated with it, individual kind of separate policies, or they have to be not integrated into the plan, and then proper notice. So that's kind of the overall summary. What does that mean in practice, in detail? Well, the scope is going to be specifically related to items and services that are around diagnosis, mitigation, or treatment of infertility or infertility-related reproductive health conditions. The maximum lifetime dollar limit you can see will be $120,000 per participant, which may sound kind of like a crazy number on paper. However, these types of services and benefits have historically been very expensive, and why sometimes you see an uptick in plan participants asking to have more access to those or better access in network access because they're very, very expensive. Certain services can cost tens of thousands of dollars alone. So that number may seem a little bit scary at first, but is pretty indicative of what the average spend might be in that category. The third kind of point there is, in order to make this fit the test mold, is this has to be under a separate policy or contract certificate, or it otherwise has to be not kind of integral or fully integrated into that major medical plan. So these truly need to be separate benefits on paper, in practice, functioning a little outside of the regular scope of the major medical plan. And then that last item is just making sure that there's proper notice to all the participants that describes how this coverage works, limitations, network access, submitting claims, the usual things that you would have in your notices, nothing kind of outside of the norm. Why does the exemption why are we talking about this? Why do we want that accepted benefits exemption and what is included in there? Well, those accepted benefits are generally exempt from HIPAA portability requirements and many of the ACA market reform requirements. However, accepted benefits are not exempt from ERISA, and in many cases, they still are in the COBRA bucket for compliance as well. So you're not really escaping everything, but you are getting out of a good amount of to-do items annually. What are we talking about for that HIPAA portability rule and that exemption? Well, generally, under that rule for group health plans, they must allow a number of mid-year enrollment kind of special enrollment rights. You have to follow that protocol. You cannot impose restrictions on enrollment or coverage based on pre-existing conditions. And you also cannot discriminate based on health status. That's the usual rules. So accepted benefits can get out of that. And the ACA market reform exemption, you'll see, also covers a lot of different things we talk about for our major medical plans now, that the accepted benefits would gets you kind of not have to abide by every year. That includes preventive services with no cost sharing, waiting periods limitations, prohibitions on annual or lifetime dollar limits. Obviously, number three wouldn't apply because you saw before this rule actually designed a lifetime kind of dollar limit built in there. Annual out-of-pocket maximums on essential benefits and coverage for children up to age 26. So that was kind of the biggest change back in the day when we were talking about coverage is you have a lot of those expensive claimants, if you want to call it that, dependents that sit on the plan for a while. Those would not be applicable to those accepted benefits plans. You would not be required to cover them. And I did see potentially a question pop up in here, which I can take a pause and see. But that's it. Oh no, it's just access today's slide. Forget me. I'm a guest speaker, so I have no idea what's happening. Do know compliance, don't know how the questions work.
I was just going to add, Marcia, I didn't see any questions yet, but I think, the other place that this is interesting to us is they're doing this specifically around fertility benefits today. That is a topic that there's kind of increased focus on having coverage for and maybe making that accessible beyond what's typically available with the group medical plan. We have that in other places too. And then that ties back to that initial poll that we did today with weight loss drugs. Could they do something similar there? Would they create some type of criteria and say, if you structure an HRA, for example, and the criteria is A, B, and C, and it's specifically for weight loss coverage, might that be an accepted benefit? Wouldn't today if we just looked at it, but they might create some special rules and do something like that. They could do it in other areas as well. So I think this one's interesting. We're kind of watching and see if they might borrow from this framework that they're proposing specifically to fertility benefits and have it be in other places too. Just gives a little bit more flexibility. You can more easily offer it on a standalone basis. You can more easily offer it beyond maybe your just typical full-time eligible employees and then avoid some of those other compliance requirements at the same time. So we're focused specifically on fertility benefits today, but the broader kind of discussion around accepted benefits is interesting as well.
I would say too, to your point, one, we don't have a lot of definitions for some of these buckets, and folks like us have been giving answers on a very complicated gray, well, it depends kind of scheme. And having this defined, especially for fertility benefits, which has historically been very undefined how we want to lump those in as different standalones or not, is a great step forward, I would say, from a compliance perspective. And Reagan, to your point, if we could get that for some of these other popular kind of benefits that everyone's asking for, it would be a great step in the right direction if that's where they're going.
And then before we move on, just one quick question. I know you went through the criteria around the different things that have to be met in order for this benefit to qualify as an accepted benefit. And one of them was the $120,000 cap. And the question was whether that was in total or if that would be per individual so that they could do it more if it was family level coverage.
The per participant was the rule. So presumably per actual participants total. Now, like I mentioned, the comment period just ended this week. So do they make changes before that final rule goes into effect? We do see that a lot. That may be something that someone has commented on is that per participant and their partner. Is it per participant and someone else, or is it just per plan? Because the way it was written was per plan participant at present. But like I said, it's proposed. So something to keep an eye on and see if that was something on their radar as well.
I think that's it.
Perfect. And we'll move on to an even more exciting topic, tobacco surcharge cases. You have to have a little bit of fun in compliance sometimes. And these, while maybe a little bit of another term we haven't hit on in a while, or we were hoping we weren't going to talk about ever again, tobacco surcharges. So tobacco surcharges and or different options that you have for incentives have been around and an option for employers to incentivize employees that are tobacco users to either not smoke or encourage them to use products to get towards healthier habits. Those employers can use higher premiums on employees, or the tobacco users can be incentivized to do something else, whether it's a quit smoking program, tobacco cessation products, any of these different options. Sometimes they're classes and different means of reaching that healthier lifestyle, if you want to call it that. Unfortunately, what happens when we go these routes is many employers don't know that this creates a wellness kind of plan that is now subject to wellness plan rules. What are those wellness program rules? Well, and where do we get this kind of title from? Wellness program rules come from us trying to figure out how to keep a little bit of control on these kind of ancillary extra plans. These wellness programs are basically incentives tied to the group health plan that must meet certain requirements to avoid violating HIPAA non-discrimination rules. Your ERISA plans and HIPAA and the ACA, if we remember, are all woven together and they overlap a lot to try and kind of meet those compliance requirements. And these wellness programs in particular need to meet these requirements in order to not kind of land back in the bucket where they have to follow all those other non-discrimination rules. What are these kind of requirements for these plans to stay compliant? Well, they have to have incentive limitations, reasonable alternative standards, which you often see as an acronym, that kind of RAS, and then confidentiality notices if medical testing is involved for them. What are common types of tobacco-related incentives that we see in plans? A lot of times we see contributions to those account-based plans, HSAs, HRAs, FSAs. Decrease in employee contributions towards their medical coverage. So that's going to be your surcharge, which in the alternative, they would have been charged more for being on the plan as a tobacco user. You may also see cash, gift cards, or entries into a prize drawing, depending on the company. Just something important to note and include kind of when you're thinking about it. If the incentive does not affect the group health plan, then HIPAA wellness rules do not apply. You don't have to follow the limit, kind of the incentive limit built in, unless there's medical testing involved to kind of prove one way or another that you are or are not a tobacco user. If it is tied to the group health plan, though, employers are kind of that's where they sit usually. They're more likely to impose a tobacco surcharge, which is that higher premium rate on those monthly employee contributions as tobacco users. And this now triggers that HIPAA wellness rules bucket of incentive limits and those reasonable alternative standards to kind of earn their incentive back. There's a 50% incentive limit built in, and I'll get more into detail about what these are here in the next few minutes and what that kind of reasonable alternative standard is to make everything right again and even. Incentive limitations, so tobacco-related incentive limits, like I said, 50% of the total cost of coverage is what you're looking at, employer plus employee contributions combined. If the incentive is applicable to only the employee, so it's only available to the employee, the incentive limit is calculated based on single coverage. If both the employee and spouse are eligible for these incentive limits, then the incentive limit is calculated based on the cost of whichever tier of coverage they're enrolled on. So might be a little bit different math in there, but it is the same base mathematical equation. And then the reasonable alternative standards is going to be a lot of words. The gist of this step, because we're talking about non-discrimination as being the base logic for rules for these plans, we're making sure that if we're going to charge a certain bucket of individuals more to be on the plan because they're tobacco users, that there are reasonable alternative options for them to kind of earn that money back. Wellness rules require that those who can't satisfy kind of the original option, which would be just quit smoking. That's probably the most original option that you'll see in plans, that they must be offered an opportunity to earn that full incentive back by satisfying a reasonable alternative. The employer should allow for a period of time also for completion of that other option. And then if satisfied, must provide the full incentive monetarily available to the non-tobacco users as well. You have to kind of think about it as everyone has to be made whole at the end there. So if you're charging someone more, they have to be able to get back down to zero and vice versa. Tobacco cessation classes or using tobacco cessation products is a common option to provide as a reasonable alternative standard. Like I said, a lot of options will start at, well, you can quit as step one, or you can take steps towards quitting as another option as well. If you're providing those tobacco cessation classes, they have to be provided at no cost, and the timing must be reasonable to complete those. If you're providing the tobacco cessation products, then you can do the kind of cost requirement that's allowed. And some of the coverage may be provided under your major medical plan as preventive coverage. If we think back to the other ACA rules and different essential health benefits, tobacco cessation products does fit over there in your preventive coverage. So you may be able to do some coordination to that effect for those folks on the plan. Why am I talking about this though? Where did I wake up and go, you know what, tobacco cessation is a hot topic today? Well, it is. There has been a significant uptick in litigation, not only in this year of 2026, but 2025 saw a giant leap in class action lawsuits against employer plans, challenging the legality of tobacco surcharge designs in general. There are some folks out in also kind of the world of mental health and lobbying and different kind of measures of rules at the government level that believe that these programs are unfairly targeting employees who struggle with addiction. So that's a common argument that comes up against these options. But employers continue to use this strategy to help curb plan costs, as these claimants oftentimes, from a data perspective, will cost more over the lifetime of the plan as tobacco users. So it's still a very, very common design that we see implemented in these plans to kind of recoup a little bit of that. What are we talking numbers wise? 2025 saw 50 class action lawsuits, and there actually might be more than 50, challenging tobacco surcharge plans under employers. 2026 is trending pretty close to match or potentially surpass those numbers. I have a case written down that just happened before this week. So you probably saw some news about a couple of cases in which this was the hot topic. And the two cases that I'm going to kind of use as examples today, I kept it food themed. Waffle House and Whataburger are both being sued right now by their plan participants around their tobacco surcharge wellness plan under their employer-sponsored plans. And they follow a very, very similar outline to this litigation summary. Almost all the cases look about the same. They're all class action suits from employees targeting the tobacco-related wellness programs. Almost all of them cite violations of HIPAA's wellness program rules, specifically targeting a failure to properly offer, disclose, or administer a reasonable alternative standard, which, thinking back a couple minutes ago, should have been a little bit easier to set up. But we do notice that a lot of plans maybe miss the mark a little bit on setting that up, especially when it comes to timing. And what do I mean by that? Well, Waffle House and Whataburger have almost an identical case profile. Waffle House in Georgia had a tobacco surcharge program that this class action lawsuit came up about that was charging about $92 a month extra for tobacco users, which equates to about $1,100 extra a year that they were paying to be on the plan. And in their court kind of complaint, there's an alleged failure to meet those wellness program requirements through their Quit for Life program. That program was offered to help them quit. It was these classes to quit tobacco usage. However, in the complaint, it says that if you completed the course after September 30th of the plan year, you never received a refund of that incentive money or that surcharge, and you could only avoid the fee going forward. So basically, they would miss a whole plan year of getting that money back. They argue that that doesn't meet the alternative standard reward kind of scheme that you're supposed to do, and also claims that it failed to notify employees that the program existed, how the program worked, some of these timing requirements around the program, that basically they were not fully informed. And then the Whataburger case, like I said, almost identical. Employees were paying about $900 extra a year for their tobacco surcharge program. They also had a smoking cessation program that ended by September 30th. I would love to know who out there is saying September 30th is the day that everyone must quit their tobacco cessation program or complete it to get their refund. But, it's a little odd. It's happened twice in a case right in a row. And in their case, they also said that later completion denied them the benefit and failed to offer kind of this reasonable alternative standard. Why do we care? Because if it's coming up almost identical and there's class action lawsuits being filed in every state against a lot of employers, then clearly there's a lens around this as a hot topic. And employees themselves too are saying, how do I save money on my plan every year? And if you're one of the individuals that's a tobacco user, you might be paying $900 to $1,100 to more dollars a year extra on your health plan, when we know that premiums across the country are also always going up right now as well. So a lot of times we see this uptick in cases when they're around a hot topic, or like this one might be very much related to the extra annual costs we're talking about. All the court decisions that have happened already with these class action lawsuits almost always depend heavily on the plan language, those notices, administrative procedures. So we're talking about that timing of completing the course or other options, and the judicial interpretation of applicable regulations. So what is reasonable? What is a good alternative? How did they set up kind of reasonable education or notification processes? And we're going to think a lot about how we do the rest of the notices in our plan for these, or what do we consider, prompt information for plan participants. And then before I hop away, I saw something popping up. I don't know if you have questions.
Yeah, we do have one general question. It's not necessarily about tobacco surcharges, but it's related to what you described. You went through and talked about the tobacco surcharge and then said HIPAA rules that you just talked about, they apply if it is tied to the group health plan or affects the group health plan. That's when those HIPAA non-discrimination rules come into play. And so it was just a question about, can we talk a little bit more about when you say that it's tied to the group health plan or affects a group health plan, maybe we can give an example of when that is the case and when it's not, so that they could understand when we have to follow these HIPAA rules.
So, and I also talked myself into a circle on that one. That's how complicated this is.
Yeah, well, and one way to think about it, and I think sometimes we have different programs. I don't know if tobacco surcharges are a good example, because the reality is they are very often, as you said right in your slide, they're more often tied to employee contributions toward the group medical plan. And the idea is to kind of drive down costs for the plan by helping people manage those. But we could have things like a walking program. And sometimes we do this walking program and then we get HSA dollars, or we get, a reduction in our employee contribution toward the medical plan, or we get a contribution to a health FSA. Those are all tied to group health plans. But sometimes it's just a gift certificate. If you do this walking, we want you to be healthy. We want to encourage that in the workplace, but we're just going to give you a $100 certificate if you participate in the program. Well, the walking program and the gift certificate, that's just cash, basically. Neither one of those things are tied to a group health plan. So it's still a flavor of a wellness program, but we wouldn't have to follow the HIPAA rules. So I don't know if that helps, but just kind of understanding when this framework that Marissa was talking about would apply.
I see gyms too. I think we see a lot of gym memberships, but they're not exactly checking attendance. Like they're not saying we have to see that you signed into the gym. We just want to, like, we're gifting you your gym membership if you appear to go, or something like that. And those are very much consumer, if maybe that's a good way to call it. Like if you're getting a extra consumer incentive and less around your premiums on your health plan.
Right.
That's
Then it's
probably
not tied, it's just we're encouraging wellness and we're giving you something that the incentive itself, that's what we're most often looking at and seeing whether that is a group health plan benefit or not. That was it though. Thank you, Marissa.
perfect. I was like, I saw a question, so I'm like, just making sure. Now off to our third, potentially the hottest topic this week in a different space, New Jersey Medicaid enrollee fees, which is technically what they're called. Now, why do we care? Because we're ERISA plans or we just don't always think about state rules specific for employer benefit plans, depending on our design. Some do, some don't. Well, New Jersey legislature, they passed a bill, including governor's signature, to call it a fine, but it's technically an annual fee, some employers with workers enrolled on Medicaid. Very interesting strategy. Also, not the first time we've seen this, and I'll get into what I mean by that. But this new law is charging annual fees to companies that have at least 50 employees covered under their state Medicaid program and enrolled. So, not 50 employees in existence at their company. So, a little bit different than that kind of large employer bubble. We want 50 employees actually enrolled and covered under that state Medicaid program. The bill also calls for those large employers to pay that in varying amounts. So there's kind of different fees or penalties, whatever you want to call them, based on employer size and based on how many folks they have enrolled in Medicaid for the state. And it's going to be based on the plan participant and their family members enrolled on those publicly funded health insurance programs. The cost of the fee depends on how many folks are on there. It doesn't depend on company size. So that's really important to keep in mind as we go through this. Yeah. Woo. Why are we talking about this? Where did this come from? There has been a lot of discussion, good, bad, ugly, over where public funding, especially federal funding, state funding, is coming from for a lot of programs across the country. Medicare, Medicaid in particular has had a large lens under how much money we spend on it. Where does that money come from? How does that get split amongst the federal budget being sent over, states' budgets being over there? Whole big thing we don't have to get into today, but that's kind of why this is coming up. We cut back a little bit on federal funding. A lot of states go, okay, how do we recoup that? How do we make sure that our balance sheet is still covering everything we want to or should be covering each year ourselves without putting ourselves vastly in the hole? And this came up specifically in New Jersey. There was a report done from 2024 numbers that they looked at in 2025, thinking about this rule from the State Department of Human Services. They're the ones that oversee Medicaid in New Jersey and often every other state. There were nearly 750 companies, nonprofits, and government offices that, based on this rule, would be subject to the fine or the annual fee. They had enough folks enrolled on the state Medicaid program that they would be qualifying under this rule. And those specific individuals that were enrolled in the state Medicaid program totaled about 382,000 plan participants or individual people associated with these companies and these are the numbers from this report, that were costing $427 million over just 3 months of time on that plan. 137 million of which was coming directly from state Medicaid funds, which comes from tax dollars. So that was kind of where this landed in the New Jersey regulatory spectrum. From this report, they came up with the rule that I talked about right at the beginning that's targeting employers with larger populations on Medicaid. So it's good to keep in mind that they really want to focus on the folks that have larger employee populations that are currently enrolled in those state insurance programs. Now, we're not talking voluntarily going to the marketplace and using an ICRA. We're talking about low income or other qualifying factors in that they get to have the Medicaid benefit. So very different scenarios that we're talking about there. In this report in particular, and like I said, this is just New Jersey, we could certainly think about this in other states, and I'm sure there are other similar reports. There were 30 major employers with employees in the state that had kind of what you want to call egregious numbers of folks enrolled on the Medicaid program, and that they were costing a lot of money. That's what I mean by egregious. They had very high cost buckets. Amazon, Walmart, and Century 2 Staffing, a company, and you'll see the numbers there, thousands of employees, family members, all considered full-time employees that qualified for state Medicaid programs, which would mean that they're likely qualifying based on income or otherwise qualifications. What are these annual fees kind of based on? They're based on the number of employees that exist and are enrolled in Medicaid over there. So we're not talking number of employees that exist at the company. We're talking per head enrolled on that state Medicaid program. So the fee is directly correlated with the employee or dependent. I'm just doing a little belly buttons count if you want a little ACA lingo put in there. And they're done in tiers. So the annual fee goes up the more folks you have enrolled in the state insurance. So 50 to 249 employees, it's going to be $325 per person. 250 to 499, it's going to be $525 per person. And then if you have 500 plus employees enrolled in Medicaid, you're going to be paying $725 per employee and dependent on the state Medicaid program. Now, what are we talking about for timing for this? March 1st annually, the state will actually inform the employers the number of employees that are enrolled in their state Medicaid and the total payment for that fee required. So this is actually nice if you want to think about it, and that the state will simply send notice and say, you have this many folks enrolled. Based on that, it's this much per person, and here's the total fee that you need to pay us for all of those individuals sitting on the state Medicaid program. Future updates will be provided, since it's a brand new rule, on how those payments will be kind of taken care of, what methods available. One of the articles mentioned that they may have an online portal, very similar to what a lot of kind of IRS or other state tax organizations have now, where you can deal with your online payments that way. And that those will be available kind of by April 15th. Of that deadline of each year. Now, obviously, we're past that right now, but that's kind of planning forward. If they make any changes when they give that March 1 notice out, that they have a little bit of a window of time to say you have until April 15th to do it, or for us to make any changes. Now, they have also announced that future guidance will be coming out. So there may be a little bit of functional procedural changes in here. They certainly have their power to change the kind of timing and the due dates as well. Something to kind of keep in mind though, when we're talking about risk or worry, or if you have employer plans in New Jersey and you're thinking, uh-oh, like this is something we need to think about, there's a lot of exceptions built into this specific rule. And all those exceptions align very much with individual kind of qualifications for Medicaid. So we're not talking about folks that qualify for Medicare, Medicaid as a separate qualification from lower income or otherwise. So individuals with a developmental disability, intellectual disability, or permanent physical disability that would qualify for Medicaid regularly, we're not counting them in the head count because they're likely going to be on those programs, whether they have the employer other plans available. An employee who has worked fewer than 90 days at the time the fee is levied. So brand new employees won't go into that head count either because they've only been around for 90 days. Part-time employees and seasonal employees as well. Something to keep in mind here, though, with this rule, there were also certain clauses written in to kind of dissuade employment decisions based on getting to these exceptions. So this rule in particular also included a section saying that you cannot make employment decisions based on trying to get someone to a part-time employee or seasonal employee status or to get out of paying this fee. So that would then give those employees kind of a right of action in New Jersey if they think their employer made some decisions about hiring, firing, hours, different options in there based on trying to kind of avoid this annual fee penalty. Planning ahead for what are we talking about? The law went into effect July 1 of this year, but we won't see that first status, that first fee math equation done until July 1 of 2027. So there's a whole year to plan ahead. I know that we said things about March dates, April dates. They're saying that first status won't happen until July 1 of 2027. So like I said, they did say there's more guidance to come out about some of that timing, the online platform, kind of different regular administrative tasks that they don't have the answers to yet. And employers can dispute any fees calculated, but they will need to track their supporting information. Big pause there, though. If we're going to track any supporting information, we want to be very careful what we're keeping track of. And why do I do a little bit of a hesitation there? We want to be very careful when we are tracking certain qualifying personal health information or otherwise things. Now, obviously, we track some of different things for health plans, benefit plans in general, but HIPAA is still a rule. We just want to be very careful planning ahead how we want to track these different things versus hours, status as a full-time or part-time employee. That might be very just business kind of payroll oriented and less around medical qualifying factors. Is this new or trending regulatory action? Well, it's trending. New Jersey may be the first one to put it out this year, but Connecticut and California have proposed their governors a very, very similar annual fee surcharge to recoup costs on state Medicaid programs, just to kind of offset those state budgets. I also wanted to put in that this isn't new historically. Massachusetts enacted but did not renew a similar rule back in 2017-18 timeframe. And then Maryland took a similar approach all the way back in 2006, but they only specifically targeted Walmart. In that particular circumstance, Walmart had a really, really high number of employees enrolled on that state Medicaid program, and Maryland was seeking to kind of get a little bit of money back on that one. And then before we move on to that, do we have any questions on that rule or no?
We didn't, Marissa. I think you can keep going.
Perfect. All right. So I'll breeze through here, take a breath, take a sip of my water. Last kind of regulatory update, which is really just a case hot topic. CVS won their ERISA preemption appeal in Arkansas around one particular state PBM rule. So Flowers v. Caremark went all the way up through the appeals court in Arkansas, and then went all the way up through the federal appeals process in the Eighth Circuit Court of Appeals, and CVS won that one. And the court said that the Arkansas statute regulating PBMs was preempted by ERISA. Just as a quick kind of review, what do we mean care when we talk about that? Meaning when we have a state law and a federal law that are very closely related, and there's a whole explanation for preemption, do we have to follow both of them? Which one do we follow? And we often, for those ERISA plans, lean on ERISA overriding that and being the overall rule. This particular case had to do with geographic coverage requirements for PBMs, and in it mandated that the PBM kind of serve as a health plan, ensuring a very high percentage of folks on the health plan lived within a relatively short distance from network providers. And you'll see the percentages and distances below that in smaller print. And in the ruling, something we want to kind of think about, and when we think about all these cases and whether they will go into effect or not, or whether ERISA preempts them, for this particular one, and they discussed geographic coverage requirements in general, they said the practical effect here was that it was kind of making PBMs tailor or retailer their networks and perhaps even build, and this is a quote, additional brick and mortar pharmacies to comply with the standard. The court ruled that this interfered with plan administration. And something to keep in mind is this is only limited to this federal circuit. I know that's probably the worst attorney answer that you can get for that one, but until it is a federal law and it is a federal interpretation at present, it really only is an opinion in that Eighth Circuit, but it does affect that whole circuit. So we may soon see kind of a significant decrease in those state regulations of PBMs in that circuit in particular, and also very, very kind of fine-tuned to those geographic requirements. And then another kind of PBM litigation update. So Tennessee actually sits in a different district for federal court purposes, and why we're just going to see a million cases still popping up. A lot of states are still passing PBM specific, TPA specific legislation to either have them have geographic requirements, network requirements. We've seen a lot of annual reporting pop up. I've seen a few states recently asking for copies of RxDC reporting from PBMs and TPAs. So I wouldn't say that, those new rules are decreasing to any effect, even though CVS may have won one Arkansas rule case, because we still see that Tennessee has plenty of rules going as well and new litigation. So a handful of PBMs are challenging Tennessee's legislation restricting vertical integration between the PBMs and the pharmacies. What do I mean by that? This in particular, and CVS is involved with this one as well, we're talking about when the health plan PBM level and the pharmacy network are essentially the same companies. They have the same parents or the same kind of family of companies. CVS is a great example just because most folks know the name. CVS Caremark may tell plan participants that their preferred providers, preferred pharmacies are CVS Pharmacy, which is under the exact same overhead company as CVS Caremark. So the Tennessee rule was specifically around restricting that kind of preferred networking, or kind of what they called pushing plan participants to use their own company's resources, is one of the quotes that came from Tennessee. The arguments challenging the rule are federal preemption, so the ERISA preemption, constitutional challenges, so always throw that in there for federal court cases. Limits on state authority over employer-sponsored benefit plans, so that directly correlates to the kind of ERISA of it all. Because the main focus for ERISA was really to have one national overarching rule. And a lot of times these kind of state level regulatory actions kind of bleed a little bit over into that. And then the litigation follows kind of the same legal strategies that we have seen work so far. So in that Arkansas challenge, in any of these other challenges that we've seen, Oklahoma also had a lot of them. I'm trying to think of all the states that had a lot of actions. Florida got challenged on their PBM rules as well. Everyone really across the country that has PBM TPA rules right now is getting challenged, but same argument across the board. Why do we talk about this? The big picture, PBM regulation remains a rapidly evolving legal landscape. We don't have a perfect answer. We don't have kind of one way to think about these preemption questions. Recent court decisions strengthen ERISA-based challenges, but like I said, it's not 100%. They're still fact-based, and they're still rule-based kind of for whatever the statute in the state says. States retain authority in some areas, but they really are facing a lot of judicial challenge to all their rules. Employers, carriers, PBMs, and providers should just kind of have an ear to the ground. Closely monitor ongoing litigation, especially in your federal court district or in your state in particular. So the news cycle there before making long-term compliance decisions, because we don't have a crystal ball, unfortunately, and we can't say that perfectly is going to work. That won't, that will get challenged. That won't. We're really all watching to see how these decisions are going to kind of play out. There are some state rules that don't get challenged because they're far less invasive, if you want to call it that, or they don't kind of teeter the line as much into ERISA territory, or they're just not as much work, so they don't get challenged as often. But it's just important to keep eyes and ears to those, especially in your own neck of the woods. Key takeaways for that one, just continuing that kind of thought process of state PBM regulation is expanding despite all of these court cases and legal challenges. They don't seem to be slowing it down. 2 recent court cases may significantly reshape the scope of state authority in those districts, and we may see some other federal court districts pick up the same kind of thought analysis for their opinions. ERISA preemption remains kind of one of the strongest legal arguments against those state PBM laws. And litigation involving pharmacy ownership restrictions and network requirements is expected to influence a lot of future legislation nationwide. It is a very hot topic, especially when we talk about costs to plan participants, and that's part of the state regulatory argument. And now we've reached the questions. I'm going to take a breath.
Yeah, please do. I think the PBM conversation is interesting. Somebody just asked about the CAA, the Consolidated Appropriations Act, and certainly pharmacy transparency is one of the many things that's included. You know, the kind of the CAA acts, we've had multiple now over the past couple of years, as well as a transparency rule that they pushed out, where that's now where we get the RxDC reporting that we have to do. They just recently expanded broker compensation disclosures, and I shouldn't even call it that anymore, service provider compensation disclosures, where more service providers in connection with group health plans are going to have to provide disclosures around compensation. And we have a pretty significant proposed rule out there around PBMs and pharmacy benefits that, if finalized, could really change not anything that employers or brokers necessarily would have to do directly. Most of the reporting and transparency requirements would fall on the PBMs, but it would provide a ton more information to employers. And so, in addition to what Marissa's talking about at the state level, and they're really trying to put controls in place and shift how things work, work and get some cost controls in place and transparency at the state level, we've got a lot of things happening at the federal level as well. And so the question was more directly about how does some of that impact fiduciary responsibilities for employers or for medical plans? And that's appropriate. I mean, at the end of the day, we're supposed to, as fiduciaries of our ERISA plans, be taking in the right information or gathering information, taking that in, using that to appropriately make decisions about which vendors we're putting in place for the plan and the design and how it's being administered. Nobody's perfect, but are we doing our due diligence in asking questions and gathering the right information to make thoughtful, reasonable decisions on behalf of plan participants? And as we have all of these laws that require additional transparency and reporting, we're putting more of that information in employers' hands or plan sponsors' hands. They do have an obligation to take that information, try and make some sense of it. Likely, you're going to need some help from your broker to navigate some of that. But to gather that information and use that to make the best decisions that you can on behalf of your plans, especially if you're in the self-funded space. You just have a ton more kind of responsibility for how that plan is being designed and administered, where the carrier is going to share a lot of that burden if you're only offering fully insured plans. So hopefully that's helpful in regard to kind of the broader PBM kind of federal landscape.
Yeah, and I'd say too, unfortunately, complicates your job a little bit. It's a lot more news cycle when you see coordinating state and federal and smushing them together. We may find it exciting from a news cycle standpoint, but it definitely makes your analysis a little bit more complicated. And we want to acknowledge that. It does make it a little bit harder to decide. But just staying, like, coming today is a good first step, making sure that you're staying in the news cycle, you're learning, you're tapping into your emails and making sure you can see what's going on is probably the best fiduciary duty. I always say is just staying up to date is step one, and then making decisions from there and having good partners.
Yes, absolutely. I think with that, though, Marissa, we've gotten through most of the questions, so we can turn it back over to Jenny.
Wonderful. Thanks to you both. You covered a ton of content today and a ton of questions. So as we close out for our audience, you will see a couple of final polling questions coming up on your screen. If you were with us at the top of the hour, you may recall we asked you two questions around how your company covers GLP-1 drugs, and we have two follow-up questions on your company's GLP-1 strategy. So as we close out here, please take a couple of moments and respond to those polling questions. And as you are doing so, I'll cover a couple of items. The first one being we did record today's session. So if you are looking for a link to the recording, please reach out to your benefits advisor. They will be able to provide you with a link to the recording of the webinar. They will have that for you within about a day or so. They can also provide you a link to today's presentation slides if you didn't have a chance to grab those earlier today. And if you did have a question that we weren't able to get to, or if you'd like to discuss how anything today applies to your organization, please also reach out to that benefits advisor who invited you here today. They'd be happy to help you further. And again, we do want to thank those benefits advisors and consultants who are partners of Assurex Global for sponsoring today's event and supporting these educational opportunities. I am going to leave the poll up here for a couple more moments, and we are asking about GLP-1 drugs today. As you all are probably very aware, GLP-1 drugs continue to be a big cost driver in healthcare, and certainly coverage strategies are evolving very fast, and that is one of the reasons we are polling you on this topic this month. We want to be able to show you how your peers are responding and reacting to this in real time. And as a reminder, we do a write-up and a recap of the polls each month in a document we release called the Market Check Survey. And you can reach out to that same benefits advisor if you'd like to read through that document. It's a quick read, a 2 to 3 page document that again recaps these polls with just some insights and perspectives as well. And that's available within about a week of today's webinar. All right, I'm going to give it just another moment and I will share the results out with you. My sneak preview would tell you the biggest factor influencing your current strategy, maybe not a shock, over half of you are saying is the cost of the medications. And how likely are you to change your strategy over the next 1 to 2 years? It looks like A little less than half of you are expecting to maintain your current approach, but some of you are actively evaluating options but remain undecided. All right, so I will share these out with you so you can see those. And I will also mention at the top of the hour, we asked how you are currently covering drugs. We did have a notable about a third of you that said you weren't sure. So this may be just a little nudge to go check if you're one of those folks who isn't sure. That's probably a good thing to just go and check if you aren't already aware. But again, that does conclude our webinar today. Thank you for joining us. Thank you for your responses to our polling questions. We certainly appreciate your time today and have a wonderful afternoon.